Good morning. My name is Susan Trevarthen, and this is my partner, Matt Mandel. We're attorneys with the firm of Weiss-Rota Helfman, Cole & Bierman, and we've been asked to come and talk to you today about how the Fair Housing Act and related provisions of federal law can affect the work that you do on behalf of the Village of Royal Palm Beach. And so we're going to take you through a number of different issues. We're going to talk not just about the Fair Housing Act, but also about something that the village has done specifically in response to the requirements of the Fair Housing Act. That is that they adopted resolution number 16-53. That is the village's reasonable accommodation policy. And we're going to explain to you what a reasonable accommodation is and why you need one. And we'll touch briefly on Section 504 of the Federal Rehabilitation Act of 1973. So starting with the Fair Housing Act, you might ask, very appropriately, what is it and who does it protect and who must comply with it? And there are 7 protected classes that we're dealing with, and I want to linger on this point for a moment because you're going to hear us throughout this presentation talk about specific examples. But really, you can substitute any of these protected classes into those examples and you still have the concerns about whether you're in compliance with federal law. So these classes are race, ethnicity, national origin, religion, sex, familial status, and disability. So the core question we're going to be talking about is the village's law as it's written different for one of these reasons? Or if the village's law is neutral, is it being applied differently for one of these reasons? And not just the Fair Housing Act, but a whole suite of federal statutes work together to protect the rights of these groups of people to have access to housing within our country. So again, race, ethnicity, national origin, religion, sex, familial status, and disability. This is a statute that applies not just to local government, but also to private persons. We're obviously going to emphasize the local government part because that's why you're here and that's how you are interacting on behalf of the village. And this is one of the key provisions that says it shall be unlawful to refuse to sell or rent housing. And you might say to yourself, well, I'm not a landlord. I'm not, actually administering housing. Some communities do have a housing authority where they literally are acting in that manner. But the key phrase here is, or otherwise make unavailable or deny. So you don't have to be the owner of the housing. You don't have to be acting as the housing authority if you're involved in whether vacant land can be developed for residential purposes, or if you're involved in whether an existing structure can be modified to meet the needs of a disabled person. All of those things relate back to, will these people in the protected classes have the housing rights that they are given under these statutes? There are some exemptions. I think in Florida we're more familiar than most because we are familiar with the concept of having age-restricted housing. And there are some rules. It's not just random that you can keep out families, but if you structure a community so it is limited to what's popularly known as 55 and over, there's a few minor exceptions and rules that apply, then that is the legally permissible way to say no families with children. Outside of that, any of the governmental actions you might take can't be motivated by discriminating against familial status, the number of children involved, for example. And there are some exemptions for private individuals who have a small number of rooms or units. One of the things we're going to talk a lot about is disability. And I think part of the reason we focus so much on this is I think it's intuitive to understand what race or gender means in most circumstances. We all know there are some interesting new cases emerging. But this is something that can be invisible to the naked eye. A disability can be the classic blind person with a seeing eye dog or a person in a wheelchair, but many disabilities may not be as evident. So one of the first aspects to understand is that this isn't just physical impairment. It is also mental impairment. And there are also physical impairments that are not immediately apparent. You may have seen this where people talk about, sometimes people get very aggressive about handicap parking spaces and whether somebody should be there. And someone might have the capability to walk 50 feet and look normal, but if you make them walk 100 feet, they don't have that capability. So whether physical or mental, it doesn't always have to be obvious, and that's the challenge that we face in dealing with the general public on behalf of the village. So you either have this physical or mental impairment that substantially limits one or more major life activities. We're going to talk a little bit later about what major life activities are. Or if you have a record of having such impairment. So you shouldn't get caught up in the notion of, well, if this person's disabled, I have to understand that, and I have to be the one who's the arbiter of whether this is a real claim of disability or not. Because sometimes protection flows from just having a record of an impairment or having being regarded as having an impairment. So one of the big points that Matt and I are going to return to throughout this presentation is you should have a very expansive and open-minded view of what it means to be disabled, because in the federal law, it is a wide open class. There are other things that come into play, whether they really need an accommodation, but that initial question of if they're disabled or not, many times the answer is going to be yes. The Fair Housing Act requires accessible design and construction if you have 4 or more units in a project. And so that would be all the units if there's an elevator, but only the ground floor units if there's not an elevator. We've had, for some of our earlier session today, we had some representatives from your planning and zoning functions. And so I'll just take a moment to point out that our planners may, if they're members of AICP, they would have to follow the AICP Code of Ethics and Professional Conduct. And those planners have an obligation to serve the public interest and to seek social justice by working to expand choice and opportunity. They have a special responsibility to plan for the needs of the disadvantaged and to promote racial and economic integration. So as we have different professions who engage with the responsibilities of the village, those professional responsibilities may come into play as well. And I highlight that because my focus is land use and zoning law. Matt is the litigator, so he'll give you more of the litigation perspective on this. There is not just within the wording of the Fair Housing Act itself, but also in a rule that was recently adopted a few years ago, a requirement to affirmatively further fair housing. So it's not just kind of a passive compliance. There's actually in the law a requirement for local governments to act affirmatively to further the goals of the Fair Housing Act. So that means taking steps to be against discrimination and taking proactive steps to foster more inclusive communities. The goal is to provide access to the community's assets for all who are protected by the Fair Housing Act. So the way that this rule works is that there is a federal assessment of your fair housing status, and that is linked to eligibility for state or federal grants. So compliance with the law is an end in and of itself, and it's something we should be doing regardless. But it's important to note that under this rule, it also could have an impact on the village's continuing eligibility to qualify for federal or state grants. This is a program that's relatively young, and it's only been rolled out in a handful of cities nationwide, but it adds even more reasons why we need to be conscious of and careful to comply with the Fair Housing Act. So I think at this point I turn it over to you, right? Okay. Liability?
Yes. Good morning, folks. In order to understand the different types of claims, we have the Fair Housing Amendments Act, which is really why we're here. You have the Americans with Disabilities Act, which I'm sure everybody has heard of, and then you also have the Rehabilitation Act. They all function under the same rubric of if you're protected class, if you're disabled, the types of discrimination are all the same. So usually if you see one claim under the Fair Housing, you'll see the similar claim under the ADA or the Rehabilitation Act. So they're pretty much the same. But let's talk about specifically the Fair Housing Amendments Act. And you have different types of causes of action that can land you in court or to land you a HUD complaint. And I'd like to talk a little bit about it. We have disparate treatment, we have disparate impact, we have failure to reasonably accommodate, and then we also have the failure to design and construct housing with the needs of disabled in mind. I do want to talk specifically a little bit about disparate treatment. Susan, we can go to the next one. Okay, so this is what they call intentional discrimination. When you have different types of intentional discrimination, I kind of lay it out here and we can talk a little bit about it. So the first thing that you see a lot of is when a municipality adopts and enforces their policies or ordinances or resolutions that intentionally treat certain people differently than others. So what is intentional? What's an ordinance that on its face, it's called facial discrimination, treats people differently? Well, people who are of our certain ethnicity or certain disability can't live in this particular area, but other people can. That's intentional discrimination. That's facial discrimination. You can't treat people differently. And if the ordinance does it or policy does it on its face, that's considered intentional discrimination. In a case that I had about 10 years ago involving a municipality in Palm Beach County, it dealt mostly with sober house regulations, and that's kind of really what my experience in fair housing and ADA focuses in on. A good amount of the ADA law and fair housing law deals with sober homes and people who are disabled. In that particular instance, the city passed an ordinance that said that if you drug test, then you're considered a substance abuse treatment facility and you can't locate within the city's residential areas within the city. And in that case, the court held that while the city had good intention, because what was going on is you had all these types of treatment facilities that were locating in neighborhoods. And the city was trying to figure out, how do you regulate, how do you get these commercial medical uses out of residential areas? Well, they all drug test. So, because they all drug test, let's target them and let's see if we can regulate them that way. And the court held that by targeting them, you're targeting their residents, people who need to be drug tested, people who are in recovery from drugs and alcohol. And as a result of that, the court found that that was a type of facial discrimination, intentional discrimination, excised that part of the ordinance out. Again, the court found that the intention was good from the city, but it was overreaching and it was a little bit too targeted. And in that case, there was a finding of intentional discrimination. Again, you have another type of example where you allow in a certain zoning district, a hospital or a nursing home, but inpatient drug treatment facilities aren't allowed. So if you have outside, it's in your medical district, you have all these types of medical uses, but you don't allow, inpatient drug treatment facilities, clearly that is treating them differently, and that would be a type of intentional discrimination. As I was talking about a little bit about the sober homes, a lot of cities have regulations that you're only allowed to have X amount of people, unrelated people living in a home together. A lot of these sober homes like to have more. They'll have 6, 7, 8 people. Usually you'll see the limitation about 3. And if the city allows unrelated persons to live together, like fraternity homes and things like that, but they don't allow sober homes because they have too many people, again, that's a type of intentional discrimination. And that's kind of what that next prong is when you enforce a facially neutral ordinance in a discriminatory way. What does that mean? Well, the ordinance on its face treats everybody the same, but if the city or the municipality enforces it in a way where it's only targeting certain protected classes, that's a type of intentional discrimination. That's known as selective enforcement. You have something that's neutral policy, but you're enforcing it in a way that's discriminatory. That is a type of intentional discrimination, and it's in violation of the Fair Housing Act and Americans with Disabilities Act. And the last one is when you pass a facially neutral ordinance or a policy, but you do it with a discriminatory purpose. If there's a big anti-sober house fervor, and they come and the elected officials come up with a policy saying that we're not going to allow, any provider that has more than 5 people in a particular neighborhood, and you're not targeting a specific use, but it's clear as day that they're passing it in response to the anti-public sentiment. That's a type of intentional discrimination. And it's also very important that when decisions are made relating to policies and ordinances and whatnot, that they're not done in reaction to public sentiment. I mean, there's a First Amendment right. Public can come and speak, and they can say whatever they want to say, but the elected officials, people in leadership positions have to be very careful that when decisions are made, that they aren't being based upon what the public says, especially when public comes out with negative comments towards a particular protected class. You've got to be very careful. I've had a situation where a planning and zoning board member said something very negative about people in recovery, and I got an injunction entered against my client because they said that was enough, even though it was not a binding decision. It was not, the planning and zoning board is not it was an advisory board, that it still was something that was considered potentially a discriminatory intent that was imputed to the city. A more concrete example I want to tell you is there was a time also, same case, where we had the elected officials up here, and they were all quiet, and you had 30 people in the audience speaking, some positively, some negatively, and one person on the dais said, "I agree for all the reasons set forth here tonight," and as a result of that, the court found that that was enough to find discriminatory intent, not just for that one particular elected official, but for the entire city. So we got to be very careful that any decisions being made aren't done in reaction to anti or public sentiment or negative things said by the public. Okay. Yes?
You talk a lot about future ordinances. How about existing ordinances as far as like disabled people? Like we've had people come in that need therapy pools or maybe need to add a ramp to the front of their house that may not meet setbacks or whatever. Is there any kind of prohibition against enforcing zoning regulations that would not make it handicap accessible? Or
So first, we need to repeat, because they're taping this for future watching. And the question was if you're talking about the application of existing ordinances as opposed to the adoption of new ordinances, do the same rules apply? And the answer is yes.
Yes.
You know, this is a particular area that Matt is talking about because it's one that we have seen numerous cases arise from, and it's counterintuitive. Most of the time, what gets said by the public is not imputed as the intent of the community. Most of the time, what's said by an individual elected official is not imputed as the intent of the community, because after all, an individual member of council really can't accomplish anything. They only can accomplish something as part of a majority that votes to do something. So in this case, it was twice removed that the public was saying discriminatory things, and at the elected level, someone made the unremarkable statement on other kinds of approvals. I move to approve based on everything in the record this evening. I mean, that doesn't sound remarkable, but because there were discriminatory comments from the audience, that was enough to get the city in trouble. So to your question of existing ordinances, absolutely. And as we talked about, it doesn't have to be facially discriminatory. If it is the same rule for everyone, but the need comes, as you say, for a therapy pool or a ramp or an exemption, sometimes you'll see with regard to animals, support animals. All of those things may trigger a situation where you need to inquire further, because it sounds like you work in the building, zoning, and planning area, and we're accustomed in that area to first examining, is there a basis for a variance here? And we already have processes for variances, but they have to prove hardship, they have to jump through all these hoops. What's unique here is if the need for a variance arises out of their protected status. And for those kind of cases, it's usually disability, the ramp, the therapy pool. Then you need to steer those people in a different direction. You need to send them to the reasonable accommodation, which has less demanding requirements and different timeframes that respect these people's rights under the federal laws.
so it could actually impact your setback requirements.
Sure.
Even though they're neutrally
Exactly. And
Yes.
so the
You
example,
may not be able to require them to get a variance, you may have to go through a different process.
That's right, and we're going to get to that in terms of reasonable accommodations. And in fact, just to go on that a little bit, the law is very clear. And again, reasonable accommodations, and we'll talk a little bit more about them. It's a streamlined way of people trying to get exceptions to whatever existing regulations or prohibitions or whatnot in the city's various different codes, LDRs and things like that. And the law is very clear that if somebody needs an accommodation, they can't be forced to go seek a variance, or things like that. That would be a violation of the Fair Housing Amendments law. I know it's surprising, but it's true. To make them go through the hoops of going through the whole administrative process of the zoning administrative process is considered anti-federal fair housing and ADA. Yeah. Yes, sir.
You mentioned in the last one, that's why we're here. Someone came in, needed an accommodation, we sent them the variance route. That, in this particular case, was determined to be wrong, and that's why we're here. We adopted a accommodation
Procedure. That's correct.
and that is well, should have been a way of doing business for a long time, but now it's going to be, we have to take off our regulatory hat, put on a customer service hat, and on these particular situations, and go down the accommodation process, not the variance process, under the right circumstances.
I just wanted to clarify one more little nuance. Okay, we have pervious area requirements to prevent flooding throughout the village. Is that even subject to?
so let me catch up with the tape, because this is not going to be audible to the tape.
Sure.
So as the manager pointed out, this distinction between a variance and a reasonable accommodation is exactly why we're engaging in the training here. And the village does have this 2016 resolution that establishes the reasonable accommodation practice or policy. The next question was whether impervious service ratios could trigger this. The prior question was a setback. And the answer is going to be for anything you can think of, anything in the entire zoning code or building code. If there is a way that it affects them, that uniquely because of their disability, it doesn't matter what the rule is. What matters is the impact on them. So it's this disparate impact, facially neutral policy that's applied in such a way that it has a unique impact on them, and they need for it to be a reasonable accommodation.
And we'll talk about it. Just because they're qualified to go seek an accommodation, and they may need it, doesn't mean they're going to that we have to give it to them. So there are some protections built in, and we'll get to that. So the second type of discrimination is disparate impact, which we talked about a little bit just now, when basically you have a facial neutral policy, something that applies towards everybody that affects or has a disparate impact, a greater proportionate impact on people who are protected. And you don't usually see a lot of these types of claims where you generally have to have statistical, empirical data to show that a particular policy, procedure, ordinance, whatnot affects a protected class in a disproportionate way. Again, you don't usually have that. What you usually have, as I was explaining before, is the intentional discrimination, where either the ordinance on its face discriminates, or you have a facially neutral ordinance that is being enforced, either by code enforcement or whatnot, in a disproportionate way. Disparate impact is not we're not enforcing it, we're not doing anything. It just has an effect, a disproportionate impact on people, and we're not trying to hurt anybody, we're not doing anything on purpose. It just happens to adversely affect people who are protected in a disproportionate way. You usually don't see many of these claims. What you usually see are the disparate treatment, which is intentional discrimination, and then the next one, Susan, reasonable accommodation, the failure to grant a reasonable accommodation. So let's talk a little bit about reasonable accommodations. Reasonable accommodations are basically the statutorily provided method to seek a deviation, alteration, exception. I don't like to ever use the land use terms variance, because it's not a variance. And a modification of a rule, a policy, a restriction. And what's very important is that it has to be reasonable and necessary to afford them, people who are protected, and in this case, people who are disabled, to have to enjoy the same benefits as a non-disabled person. You probably hear about people needing seeing eye dogs, in a building that doesn't allow pets. That would be a reasonable accommodation. People need seeing eye dog. People who are visually impaired need a seeing eye dog in order to be able to function. A lot of times you see reasonable accommodations in the zoning context. As I said, in the sober house context, we have people who, these sober home providers, they want to put 10 people in a house, for example, when restrictions are you're only allowed to have 3 people or 4 people. We need a reasonable accommodation because we need to have 10 people. We need 10 people. And
Or to that point, I need the ramp, and the way the house is built on the site, I need a 1 or 2 foot encroachment into the setback, or it may take me over the impervious surface ratio, but without that ramp, I can't enjoy the same housing rights as everyone else.
right, and basically, in that scenario, the ramp scenario, to show necessity is a fairly easy threshold. I mean, obviously, you have a wheelchair and you can't get up into the, you need a ramp, and it's a pretty easy showing. In the sober house context, which I've seen a lot of, it's very difficult for them to show the necessity. And again, necessity in the fair housing context is broken down into 2 types of necessity. You have therapeutic necessity, which would be in the case of in the ramp, you need it in order to get in, or from a financial viability standpoint. Now, let's talk about therapeutic necessity first. Therapeutic necessity is where you need to have actual medical evidence, medical data, medical support to show why the accommodation that you're seeking is therapeutically necessary. And it's incumbent upon the applicant to show that. Sometimes they'll be able to show it fairly easily, sometimes they won't. In the case of sober house context, they don't really show it too well because they just say we need 10 people as opposed to 8 people or 12 people. And what type of evidence do you have? They usually don't support that. Financial viability. Financial viability is, it doesn't matter that whether you need it from a therapeutic standpoint, and I'll use, again, the sober house context just to illustrate it, but they need 10 people not because you need 10 people to treat people in recovery, but you need 10 people in order to pay the rent, to pay the taxes, to pay the bills. So even though you could probably get away from a therapeutic standpoint of 4 or 5 people, you need 10 people in there charging, paying X amount of dollars every month in order to have the house and operate the house. You don't usually see a lot of people go under the financial viability prong because they have to open up their books, they have to show all their financials, they have to show why they need it for financial viability. And the reason why they can't show financial viability because they usually want the accommodation for financial profitability. In the Fair Housing Amendments Act and the ADA, they don't protect. The need is not financial profitability, it's financial viability to keep it on. They're not supposed to be getting their accommodation so they can turn a profit. It's so that they can keep the house or keep the service available to people who actually need it. Now, I do want to respond also to what you said that, and I will get to it a little bit later, but I do want to address it. Just because somebody shows that they need it, they show that they're disabled. So they have to show that they're disabled. They have to show that they need it, but the most important thing that they also have to show is that it doesn't fundamentally alter the nature of the local zoning. So let's say, for example, people come in and they say, look, we want to have a sober house, and I have medical evidence that absolutely shows that we need to put 50 people in this 3-bedroom house. I mean, we have to have it. If we have 49 people, it will not work. We need 50 people. Well, obviously, 50 people in a 3-bedroom house is not legit from a zoning standpoint, and that fundamentally alters the nature of the local zoning. And that would be a basis to deny the reasonable accommodation request, or deny it in part and give them, a lot less people. But so even though you're disabled and you show that you need it, you still have to show that it doesn't change or fundamentally alter the nature of the local zoning and a zoning context. Okay, and then the last one, very, very important, that a reasonable accommodation request must be responded to very promptly. You can't just keep it on hold. You have to get back to people right away, because if they say they need it, and you need to address it right away. Okay.
And just to elaborate on one point from the questions that we got earlier, so Matt gave you some examples where communities have tight regulations of the number of people who are unrelated and who can live together. That isn't true necessarily in every city. Some cities have broader provisions for occupancy. So let's think back about what we heard about the role of public outcry. So because we have seen this in other communities. Oh, we can't have sober homes. Oh my gosh, that'll be the end of the world. There's this big outcry. Then either the staff people or the advisory boards or the governing body says, the people don't want it. The people are scared. Those people don't belong in our community. I heard we can have a stricter limit on the number of people who live together. Let's do that, and then we can avoid this problem. The fact that you've created that record of your intent means that something that otherwise would be okay, if it was just on your books already or if it was adopted for a neutral reason, you're going to get dinged for, because it's very clear that it was in response to that discriminatory intent. So that's just another example of how that roar of the crowd pressure can lead to problems for your community. Uh-huh.
So to avoid that, don't they have this being an issue throughout different municipalities? Isn't it just like if you were going to have a family daycare, you have to have so many square feet per child? I mean, is that, do they have something like that in place so that when they come to us, we're not so blind as to what is available to us? Like if they have a 3-bedroom house and it's 2,000 square feet and they need so many square foot for each sober person that's going to live in that home, then that would eliminate all the questions. I mean, is that in place or not?
So the question for the tape was, are there generally accepted standards that we can follow so that we know we're not running afoul of these requirements? And I would give you two answers to that. The first answer is to think about what a sober home is. It is a residence with a group of unrelated persons living together. And if you're going to do anything, literally anything, to them that's different than you would do to another similarly situated person who's not disabled, not recovering from drug or alcohol addiction, then you have a problem. And Matt came up with the perfect example while we were talking between the trainings. The Brady Bunch. Yeah, the father and the mother are married, but we don't know if they adopted all those kids, and if so, those kids are unrelated to each other. We need to always put it in the context that our homes don't necessarily have just, two parents and a child, that there are many different kinds of living circumstances. So the first thing you should always ask yourself is, well, if what they're wanting to do would be okay for that kind of family, the grandmother, the parents, and the 5 kids, which include 3 teenagers who all have their own car, they're not protected necessarily, but would you do it to them? Then maybe you can do the same thing with a sober home. And then the second question, the way I would answer the question is, there really isn't one standard, and I'll let Matt elaborate on that. It's really a case-by-case scenario.
That's exactly right. I mean,
Sure.
Maybe it's a question. But the example was comparing a business, job care business, that is regulated by the state and does have specific rules, to people living in a house. That's you can't compare the two. And you were given the example, it's just 6 people living in a house, unrelated. That's no different than the Brady Bunch family living in a house. But a daycare is a business, and there are rules for that. And that's where people get, I think, wrapped up a lot, thinking the sober home living situation is the business. It's not the business.
it's the residence.
It's the residence.
That's right.
The sober home business of getting treatment, getting whatever they get is done elsewhere.
Yeah. Basically, the just for the tape, that it's the question, or the point that's being made is that the difference between a sober house and the daycare. The daycare is a business versus a sober house, which is considered in a lot of places. Most of the time, they're considered residential. I mean, so you have some types of sober homes that are licensed, there's some on-site treatment, but for the most part, they are considered residences. And to look as a barometer how the village treats other residences, and they should be treated pretty much and regulated the same.
And that licensing question is worth stopping on. Sometimes we've heard from our clients, well, they're a licensed provider of housing for a day-night with community housing license. Doesn't that make them a business? The answer is no.
Right, and just to talk just a little bit more about that the license goes towards the treatment, which is off-site in the commercial medical area, and the residential component is, as long as there's no treatment on there, again, to be looked at and regulated like a regular house.
That's how we here in the village differentiate. Like the gentleman said, is that there's no treatment on site. When there's treatment in another place, then we treat it just like another residential home, which in fact, they don't have to come to us for licensing and the 1,000-foot separation requirements. Sometimes I do, just to let us know that they're here, but for the most part, they're a single-family residence as long as they're not providing treatment on site.
And you were going to talk about, is there one rule or is it case by case?
A lot of times it is case by case. I mean, when these they have to be looked at different. They have to be looked at and again, when we look at the requests that come in, you have to look at what is being requested and why they need what they need. And you can't ever just say, well, you know, we gave 8 for this one house, and but we can't. We have to give 8 for every house. No, you have to look at everything on a case-by-case basis, depending on what they demonstrate, what their needs are, and again, what the surrounding areas are. Because you might have a single-family home that you can put more people in, but if somebody comes in with a reasonable accommodation request in a multifamily area, it may not be conducive to as many people in a multifamily as you have in a single-family home. So you have to look at everything on a case-by-case basis. Okay.
So the bottom line, when you come talking about sober homes, which are in many municipalities, once they're there, they're there. There's really nothing you can do when people come forward and complain about sober homes and they think they need to be moved to another location. There's really nothing you can do.
Well, the question is so once you have a sober house, that's it, you're done, and there's nothing you can do. And a lot of times that's correct, but there are regulations, and again, if they are not following your zoning code in terms of if there's trash and there's things, you got to treat them just like a regular family house. So if as long
Noise,
as noise,
parking,
things like that, you can't treat them differently because they are a sober home. But you treat them exactly like you would treat any other home. And if any other home is in violation of your code, well, you can absolutely enforce your code, okay? So, and a lot of times, when a reasonable accommodation is granted to a sober house and they're allowed to exist and certain regulations are modified, and I'll get to this a little bit later, you grant the reasonable accommodation request with certain conditions and requirements that they have to follow certain things, and if they are in violation of that, then they would lose their reasonable accommodation. So there are ways of regulating and controlling, eliminating. I don't think there's really a way of eliminating unless you want to be sued in
Unless you're
federal
going to
court.
eliminate the Brady Bunch also.
Right, exactly. Okay, so who could seek a reasonable accommodation? Let's talk a little bit about that. Somebody who has a physical or mental impairment that substantially limits a major life activity. A record of having such an impairment is regarded as having an impairment, or companies or individuals that provide services to individuals that are disabled. Now, I read that very well. So what does all that mean? Has a physical or mental impairment that substantially limits a major life activity. Does anybody know what a major life activity is? Any ideas? Driving. What are you guys doing right now? Working, sleeping, eating, things like that. Those are considered major life activities. So if people can't perform a major life activity, they have an actual physical or mental impairment. Now, again, it can't just be, somebody could look on, that they don't have any type of disability. That person looks fine. That person looks normal. They're walking, they're running, they're talking, but you don't know what they got inside here, what's inside their head, if that's preventing them from working or being able to function like people without disabilities. So that is somebody who is qualified as being disabled under the Fair Housing Amendments Act or ADA. Having a record of such an impairment, you see that a lot too, where people who currently don't have any disability, currently are able to function just fine, but they have a record of being impaired in the past. They have medical evidence. And this is very broadly construed. I mean, if there are people who, 20 years ago, they were a recovering alcoholic. They haven't had a drink in 20 years. They're fine. They live good life. They run marathons. They're good to go. But they have a record of being impaired from 20 years ago. And under the case law, that is considered disabled. And I will tell you, many of the courts and HUD, they basically give a very short shrift to this. If you say you're disabled or you say you have a history of disability, they accept that. Even though the burden is on the person claiming that they're disabled to show that they're disabled or show that they have a record of being disabled, I have not seen a case where someone's fair housing claim or ADA claim has failed because they were not able to prove up a disability, other than people who were actively using illegal narcotics. Under that limited scenario, they weren't qualified under the ADA. Although they were qualified under the Fair Housing Act, they weren't qualified under the ADA. So,
But if they stop using tomorrow,
then they're
not
qualified.
actually
Then
using, they're recovering.
and then they're qualified again. So it's a very, very liberal standard, very liberal. Unfortunately, that's what the case law provides. Yes, sir.
Would depression fall under that?
Again,
Yes.
depression would fall under it if it substantially limits a major life activity. There are people who are clinically depressed who can function fine, have no impairments. But if that depression causes them to have some type, they can't work or they can't eat or sleep, major life activities, well, they're considered disabled. The third prong, which you don't usually see a lot, is that person, they don't have a history of having an impairment, and they don't currently have an impairment, but they're perceived as being impaired. For example, this guy seems crazy. This guy's just talking a lot. There's something off with this guy. Even if there isn't anything off with this guy, even if he doesn't have a history of anything, if he's perceived to be disabled, he's protected as well. Again, you don't see that a lot. You really don't see that a lot. Again, most of the claims are having a record of such an impairment, because I had an interesting case, again, a few years ago, and we challenged the plaintiff's ability to bring a fair housing claim. We're saying they're fine. Well, I'm taking their deposition. Can you eat? Yes. Can you drink? Yes. Can you do this? Can you drink? Not alcohol.
Water.
Right. But yeah, I went to the football game yesterday. I had a good time. I played basketball 5 times a week. So we sought to have the case thrown out. But what I couldn't get past was the fact that this gentleman had a history of issues. And once he proved evidence of his history, then the court said, you know what, he may not be disabled now, but he was disabled in the past, and therefore he's able to bring his claim now. That's just how it is, unfortunately, but that's just what the state of the law is, and that's what we're advising you of such. The last prong is, are companies or organizations that provide services or individuals who are disabled. So in terms of like the sober house context, we see it all the time. The applications that are received by cities are not from the actual individuals residing in the homes or the intended individuals. It's the providers. And if the providers can show that they provide services to people who are in need or who are covered under the ADA or Fair Housing Act, well, those companies and organizations are covered as well. So those are the 4 different types of categories of people or companies that have the ability or standing to seek a reasonable accommodation. Okay, let's go to the next slide.
So if we haven't said it enough, it's not a wise idea to consider yourself being in the business of determining whether somebody's disabled. There are other things that are necessary before they actually get relief, and those are things that can lead to potentially their relief is denied. But it's not a good idea for people to kind of think of themselves as self-appointed arbiters of whether there's really a disability.
Right. If somebody says they're disabled or they need an accommodation, they need to be advised accordingly. That's a perfect segue that our reasonable accommodation process that I'm sure all of you have, which is Resolution 16-53 that was passed in December of last year, that the process has to be displayed on the village's public notice bulletin board, and the application for a reasonable accommodation is on the website. So it's very important that all of you know where this particular procedure and application is located, if anybody asks you for this procedure, or how do I, they're not going to say, do I want an accommodation? They're going to say, how do I get an exception, or how do I change this, or, does this really apply to me? Those should be buzzwords that raise your radar and lead you to tell them, look, we have a reasonable accommodation procedure. It's on the website. It's on the public bulletin board. That's where you need to go. And it has to be submitted, per the resolution, it has to be submitted to the clerk's office. The clerk was here earlier, and I was directing, it has to go to her. That's just a way of maintaining all of the requests, and the way the process is set up, it all has to funnel through her. They generally have to be in writing, but they can be verbal as well. And if they are verbal, it's incumbent upon the village to document them so that we have a record of the requests and that we're dealing with them accordingly. What's also very important is that assistance, if they need assistance in getting the application filled out, or getting the application, that it's incumbent upon the municipality and the employees to help them, get them those forms, help them fill it out if they need it. And one of the biggest requirements of the Fair Housing Act and ADA, which is incorporated into your resolution, is that there can't be a fee. It can't be cost recovery on this. There's a lot of time that goes into this for consideration by the village and by different cities, and a lot of money that's spent, but under the ADA and the Fair Housing, you can't recover that cost. Under a variance or rezoning or whatever, those are cost recovery. You pay a big fee, you can get money back, but for reasonable accommodation, that's all on the village's dime, and that's just what the law is.
For practical purposes of doing my everyday tasks at the front counter when people come in to inquire, being that we're not expected to be arbiters of who has a disability or whatnot, unless they raise it, we treat them as we would any other person asking for something that the code doesn't allow.
That's exactly right. So the question is if somebody comes in to the desk and they don't show signs of or perception of being disabled, you treat everybody the same. You treat them as if they're everybody who comes in. And if they make a request that I want an alteration, or I want an exception, a modification, it's then incumbent upon you or the other employees to make sure that they have the ability to seek such modifications. Let's go to the next slide. So what goes into the application? What are the contents? The name of the applicant or the qualifying entity, the company that represents that applicant. Also the location at which the accommodation is being requested. That's important too. There is some debate as to information. Some people who are in active recovery, their information, identifying information under the law might be exempt. However, it's still important that we get the address and we know exactly where the accommodation is being sought in order to be able to evaluate the request. So if someone is refusing to provide their name or identifying information, you still have to walk them through the process. And then obviously it will go to your city attorney to analyze whether or not they really do need to provide their name. But there are some limited exceptions where they don't have to provide their name or identifying information. Also on the application, they do have to describe their qualifying disability. So again, it's not for us to say, well, you don't look, you could stand, you look fine, you're good. They have to tell you what their problem is. If they say they're clinically depressed and it prevents them from doing X, Y, Z, the burden is on the applicant or the qualifying company to show what the disability is. And what's important is the necessity prong, the necessary. They have to show not only what their disability is, but why they need the modification, and obviously from which specific regulation, policy, ordinance, whatnot, they're seeking a modification of. And then again, what's really critical is that they have to back it up. They just can't say it. They just can't write it out and say, I need this because of this. They need to show evidence, medical information, whatnot, that supports their position. I mean, they just can't say, I need it, and therefore give it to me. I mean, there has to be something more than that. So it's not, I know the concern is if somebody says they're disabled, they're just going to get it because the law is and the law is very liberally construed, but the law also is the law also requires people to prove their disability and requires them to prove the most important thing, necessity. And they also need to prove, as I alluded to before, that it doesn't fundamentally alter the nature of the local zone. That burden is all on them. So just because they do prove the disability, they do prove necessity, doesn't mean they still get it. They have to prove all those things. Okay, that's good.
And just a reminder, it's the therapeutic necessity, that it aids their disability. It's the financial viability, as Matt described earlier. The accommodation is necessary. And then, what was the third
The
part?
fundamental, they have to show that it doesn't
That's not
fundamentally
altering
alter
the
the zoning.
zoning scheme.
Right.
Those are the three things that they're going to have to show when they come forward. So just because we push them to this process doesn't mean they prevail, but it provides an orderly way of examining their claim of disability.
Just a quick clarification. The necessity, they have to prove one or the other, that it's therapeutically necessary or it's needed for financial viability. They have to prove one of those two, and they also then have to prove that it doesn't fundamentally alter the local zoning scheme.
Exactly.
Okay. The review process, the village manager or the designee shall issue a written decision within 30 days, and if additional information is required, you go back to the applicant. The applicant will submit some additional information. If they don't submit it within 30 days under your resolution, the request is denied without prejudice. If they do respond within 30 days, it resets the clock, and we have another 30 days to respond back and make a decision as to their request. And again, what I talked about before is that in the application, they have to show, again, they have to demonstrate the disability, they have to show that it's reasonable and necessary, and then again, it doesn't fundamentally alter the village's zoning scheme. Okay. Now, what can the village do? We can take the request, whatever's requested, and just grant it. We could grant it in part, deny it in part. We can grant it with conditions, or we can just deny it outright. I will tell you that most of the time, most municipalities, they do the second or third prong. They'll grant it in part, deny it in part. Somebody wants 8 people at a sober house and they give them 6. That's granting in part, denying in part. Or if they want 8 people, we'll say, we'll give you 8 people provided that you don't have 5 cars on the property at any given time. That's granting it with conditions. If you deny it outright, chances are you're going to get sued. And I will tell you that in my experience, granting in part, denying in part, or granting with conditions, I've yet to see a lawsuit from many of my clients that have granted in part or granted with conditions, because you're giving them some relief. So it's hard to say that they're acting with discriminatory intent when they are making modifications. They're just not making the modifications that are requested. And sometimes people or companies, they'll shoot high, knowing that cities won't give them everything they want, give them a little bit less. And if they get a little bit less, then they're happy with that. So I have yet to see a case where when a reasonable accommodation has been granted in part or with conditions where it's been challenged in court. Okay? So the determination needs to be in writing. It's very important. And it's also what's important is that the right to appeal the decision, they're advised of that. And it's the way it's set up in your resolution, is it would go to the special magistrate who oversees your code enforcement proceedings. Now, what's important is that if somebody doesn't like what happens at a reasonable accommodation request, they can go right to HUD. They can go right to federal court. They don't have to appeal it, but your ordinance, your resolution provides for that. And sometimes they do appeal it. Sometimes, again, they run right to HUD or they run right to court. But that's what needs to be in the response to the request. Okay, next slide.
And did we say that we can't enforce it
That's the
while
next
it's
slide.
pending?
Oh, no, I didn't say that. Oh, that's right. That's part of the slide. I apologize. Probably I missed the most important thing. And the most important thing is that while the request is pending, you can't enforce any of the subject regulation against them. So if somebody wants an accommodation from a restriction on the amount of people, and they're sticking 10 people in there and clearly in violation of code, you can't send code enforcement out there to enforce that provision while their request or their appeal is pending. So it's incumbent upon the village to address their request promptly and dispose of it promptly so that it doesn't, so that we can deal with it. Because the longer it's pending, the longer it's out there, the longer they can be in violation. And it's kind of like a safe harbor provision that allows them to operate while this is still pending. But this is what the law requires, and this is what we have to do and while these requests are pending. Thank you.
And then we just have 2 quick slides. I know we're near the end of our time. Dealing with Section 504 of the Rehabilitation Act of 1973. We were asked to include this in the training. And this is a federal statute that prohibits discrimination on the basis of disability in any program or activity receiving federal financial assistance. And in order to determine whether applicants are qualified to participate in that program, you must consider whether reasonable accommodations would have made the applicants qualified for the program. And in determining whether the accommodation applications requested was reasonable, the court is guided by decisions addressing the ADA and the fair housing. So the analytical approach is the same, even though it's nominally a different statute. Somebody wants to participate in the village's Parks and Recreation program, and there's federal funding somehow involved, and they're disabled and they need an accommodation to be able to do it. That might be an example. So with that, that concludes our PowerPoint. We're leaving this with your staff, and they'll make it available to everyone after the fact so you can refer back to us. We're happy to take any additional questions at this time.
One thing I didn't see that you covered is what happens if you take longer than 30 days?
The question is, what happens if you take longer than 30 days? Well, chances are nothing. But under your ordinance, they could, in theory, have standing to say that you're not enforcing your ordinance properly against them, and they're being discriminated against because you're dragging your feet. But the reason why practically you're not going to see a claim for that is because of the safe harbor that's in there. The longer the request is pending, you're not enforcing the ordinance against them. So it's really the motivator on resolving the issue is really on the village. It's not on the applicant. So that's why the safe harbor is very important, because if the safe harbor wasn't in there and you're dragging your feet, then you better believe they'll sue you. Because if you're threatening code enforcement, they're like, but as long as you can't enforce your code against them, a lot of times the applicants will ask for more time themselves. And you have to be careful. If they ask for 30 more days to respond for more information or whatnot, you got to be careful and need to make sure that it's a legitimate request versus a request to delay and extend the process out.
And so potentially it's manipulated to keep the status quo in violation of the code when they're not going to be able to prevail. But alternatively, if it might not be and they just need the time, so then you need to make sure and document that the delay is not the village violating its own resolution, but rather that they requested and you gave them additional time.
Any other questions? All right, folks, if you
Thank you.
have any questions after today or you're thinking about anything, Susan's information, my information's up there. Please feel free to give either of us a call or shoot us an email, or go through your city attorney or through Monica, and we'll be more than happy to get back to you on anything. All right, thank you.